Welcome to Tangents from Coin Center. I'm Jerry Brito, Executive Director of Coin Center. And with me, as always, I've got Peter Van Valkenburg, Director of Research at Coin Center. Hi, Peter.
Sure.
How are you doing?
I'm researching.
What are you researching?
No, I'm not. I was researching. I guess I'm done researching. Yeah.
You're done researching for now, I'm sure. There'll be another thing. But the thing you were researching, which we're here to talk about today, is a comment letter that we filed with the SEC in a proceeding that they had open until, I guess, yesterday, that had nothing to do with cryptocurrency or decentralized exchange or DeFi or anything like that. Is that right?
Nothing to do. Well, it's never mentioned. None of those terms, not even digital assets. There's another rulemaking pending right now on the definition of dealers, which does mention digital assets in a footnote of a 200-page rule. And in this rulemaking we're talking about today, the Exchange Act rulemaking, not a single mention. But I mean, we always advocate for technology neutral rules and laws. And so just because the technology is not mentioned doesn't mean it wouldn't be potentially subject to a rule change. And it's, we'll get into it in detail. The substance of the rule is we're going to change the definition of what it is to be an exchange. They're not changing the statute, of course, but the statute gives the SEC discretion to clarify the definition. And the rule change basically says, look, it used to be that you were an exchange because you, in the old rule, brought together orders, which makes sense, like someone managing an order book. But now it's going to be about people who bring together people who bring together people.
People helping people.
Helping
the human fund.
Yeah. And the other half of the definition, because it's a two-part sort of test, is how are you bringing these things together? It used to be by using established methods, using methods. And now it is by making available methods, rules, or communications protocols. So we are right now speaking through Google Meet. I don't know if it's bad OPSEC to reveal how we record our podcast.
I think it's clear from the formatting.
I mean, is Google, if you and I were to agree to a securities deal right now, is Google making available a communications protocol that brings together buyers and sellers?
Well,
sure. Maybe.
Yes, they are doing that, but they're not making available methods. So let's take a before we do that.
Right.
Okay. Why is the SEC doing this? Right. They don't mention. So one reason they might be doing it is to make sure that. So Gary Gensler has been on the record most recently in a speech dedicated to crypto market regulation a couple of weeks ago. He's been clear that he thinks that cryptocurrency exchanges like Coinbase, Kraken, and the like should register as securities exchanges. Okay, because as far as he's concerned, they are probably trading securities, and so they should register as securities exchanges under the Act. But what about decentralized exchange? So one reason to do this rule might be to expand. Decentralized exchange probably couldn't be captured by the existing interpretation of what the word exchange in the Act means. So,
although there's the Ether Delta settlement.
Let's hold on. Let me set the table.
Yes.
So arguably you couldn't capture decentralized exchange properly understood under the existing interpretation of what exchange means. So you have to reinterpret it. And this, you could argue, would do that. But they don't mention decentralized exchange once in the hundreds of pages of the rulemaking.
To the contrary, arguing that maybe they had no intent to do this with respect to decentralized exchange,
Yeah.
the SEC has to do fairly rigorous economic analysis, actually beyond the typical economic impact analysis required by OIRA or other, generally applying
There's so
administrators.
much to say about all this. Keep going.
Yeah. Well, anyway, they've got some specific things they have to do, and one of those things is estimate the impact of the rule change. And to do that, they had to basically come up with a number for the number of things that they're defining as communications protocols that are likely to exist in the world, and whether some subset of those are not yet registered as exchanges and would therefore need to register. And it's not even the subset of how many are not registered. It's just the total number of communications protocol systems that they estimate in the world that connect buyers and sellers of securities using these communications protocols is 22, according to the rulemaking. So, you can.
Yeah. So I was going to say one reason that they maybe did this was to capture DeFi, or decentralized exchange. Another reason is to do what they say in the rulemaking and in certain statements from different commissioners was their intent, which is that they want to capture facilities that are trading fixed income and government securities that today don't fall into this, right? So things like, and these are my words, right? Things like the Bloomberg terminal,
yeah,
right, where there's a chat box and it has a structured the program that the Bloomberg terminal offers you has a structured way to compose a message where you can list a security type, list the bid or ask price, and put in a message, and it just goes out to other traders who can. So you're not committing to anything. They're not it's not an order.
The term is non-firm trading interest.
Yeah, that's a name that Dave invented for this. That was, as far as I know, that's not a term that existed before this rule.
No, I mean it's a reasonable.
It's a reasonable term. Yeah,
reasonable term, because to a certain extent, the old definition was fairly clear that it was about bringing together orders, right?
But let me just stop you.
Yeah.
One of my pet peeves with just the way federal agencies regulate is that they invent new language and they put capital letters on it, things like non-firm order or communications protocol system, and then they begin to talk about them as if these things are legal terms.
I like to capitalize random things too, so as Barry knows from having to edit my comments before they get published.
Yes, that's true.
No, but you're right, and this is actually fascinating in the sense that, and we've had other conversations in the past about whose constitutional duty is it to make law. It's the Congress. It's not the executive branch. Now, of course, the executive branch is allowed to interpret a lot of things in legislation and fill in the details left by legislators. But Congress can't tell the agencies to just make it up as they go along. And making up whole categories of things that are subsets of maybe something defined in the statute is sort of a weird practice. It happens in the anti-money laundering context all the time. The Bank Secrecy Act has a list of financial institutions, but also allows the Treasury to add to that list. And so basically the Treasury just creates whole new categories. Like, you'd be surprised if you were an anti-money laundering lawyer who hadn't looked at the Bank Secrecy Act itself in a while, maybe that money services business is not a term in the Bank Secrecy Act. It's a term in the rules, which have a whole separate list of definitions for persons who might be financial institutions.
Yeah,
this happens all the time.
It does, but at least the BSA gives the Treasury Secretary authority, whether it's constitutional or not, a separate matter, but at least gives the Secretary authority to develop these new definitions, right?
I don't want to overclaim there about the Securities Act, though, because to be clear, our comment doesn't get into any statutory authority arguments, because as we'll get to it, we went straight to the constitutional law arguments because that's where we thought we had value add. The securities laws are incredibly broad. The statutory definition of exchange is broader than any of these rule definitions, which is very interesting. And we can get to severability if this was to be challenged on First Amendment grounds and found unconstitutional. I'm not sure if the Exchange Act survives, which is, although, we'll figure it out.
Okay, but let's okay. So they could be motivated by what they said they were motivated by, which is they want to capture things like these chat features on, whatever.
This is such a not Jerry Brito conversation.
Why? Because I'm
like, every time, oh, well, they're doing this. You're like, don't psychoanalyze other people.
No, because I'm not. So I'm not psychoanalyzing. I'm not. No, I hate to think. How do I put this? I hate to say what other people are thinking because I can't know. I very strongly abide by that rule. What I'm doing here, though, is saying all the possible reasons.
Yes.
I'm just laying them all out without saying that any one of them is the right one.
And it's true, we don't know. Like there's a large fraction of the tweets about the SEC stuff that I've seen. A lot of them do seem to infer bad faith because I think Chairman Gensler, for some good reasons, some bad reasons, has become this sort of like visible figure in the space that is often vilified. I actually have no idea in this case the degree to which there were any conversations about this affecting crypto. I don't know. You know,
I have no idea. But this is where like I want to kind of depart from my own rule. So just to say, so normally take them at their word. They want to capture something like the Bloomberg terminal, and so they came up with this rule, not realizing that they wrote it so broadly that it's going to capture all of decentralized exchange, right, and all kinds of DeFi applications, and who knows what else in the world that is outside of crypto that we're not looking at, right? Another thing is that they wrote it this way with the intention of capturing the terminal, but then realized that it would also work for DeFi, right? And the reason that some people, I think, wonder about bad faith is that there's kind of like there's a lot of smoke, right? It's not mentioned once. Chairman Gensler is out there making statements saying that these exchanges, whether they're centralized or decentralized or securities exchanges, and this staff and this commission is so smart. They really are very smart, and they're very well steeped in cryptocurrency that it's just very surprising that they would not realize. I mean, for one, Commissioner Peirce understood it. It seems.
Well, she certainly raised a flag in her dissent to the rulemaking, saying she had some other thoughts.
Yeah.
And then towards the end of that dissent, she says, and, First Amendment folks who are concerned about, potential regulatory overreach, impeding free speech, should think about what it means to start permissioning the publication of communications protocols.
I don't think she even mentioned the First Amendment.
Maybe no.
She said, I'm pretty sure that what she said was just to people who run any kind of communication system, don't think this doesn't affect you. And I think that's as far as she went to say. I don't think she mentioned.
Could be wrong. I swear she mentioned free speech, but maybe not. Maybe.
In any event, so that's the reason for why we're here. So they're reinterpreting the definition of exchange in the Act.
Yeah.
And what effect? Yeah.
Yeah. And so this is the reason why it's interesting to try and unpack past motivations or assumptions that might have been made by staff about what this applies to. But at the end of the day, it's the law or the rule on the page that matters, right? And so the fact of the matter is, as I sort of briefly recounted earlier, we're changing our definition for who has to register, which is a prior restraint. And the Supreme Court has roundly rejected prior restraint, as Walter would say. They've redefined who has to get permission and register with the SEC as an exchange from people who are bringing together objects or things, which is obviously like an action, a conduct that happens in the world, to people who are bringing together people. We go into depth in our interpretation section of the comment about how bringing together people really is persuasion, because you rarely bring together people physically like you would bring together orders on a database or a spreadsheet. If you're bringing together people physically, they're either incapacitated or convicts, like you're a jailer and you're bringing them together. Like bringing together means persuasion, so it really is speech. And then the other half of the definition is very evidently a switch from conduct regulation to speech regulation, because it's this move from using methods, which assumes, it seems, inherently that you're acting on behalf of someone specifically, who's expressed intent to you to do something, and now you're using methods to do that thing. And instead, just making available methods or communications protocols, which it's very sort of difficult language, deliberately or not. It's weird language, but there's no interpretation of making available a communications protocol. The definition of protocol is a set of rules. There's no interpretation that doesn't absolutely include publishing rules, publishing, a list of things that people are supposed to be able to do or not be able to do, which is really just publishing speech. I mean, you could do this in a book. In fact, because there's nothing in here about DeFi or crypto or even the internet per se, like this extends to someone, publishing a book on Amazon, potentially. And so because the rule is what matters and not the intent of the people who wrote the rule,
Right.
it will be interpreted in the future, undoubtedly, to include these things, because you would have to make an obscene parody of the English language to say that it doesn't potentially include these things. And so it gives, if not this commission, a future commission, plenty of leeway to go after all kinds of things that are basically just publishing speech. Like people who don't understand statutory interpretation and the way that courts do this might find this kind of weird, but this is how we want to run society. We want there to be clearly stated rules, and then a normal person should be able to read the rules. You shouldn't need to know some special fact about Gary Gensler or some special fact about Hester Peirce to look at the rule and know what it does. You should just be able to look at the rule. There's this great case about statutory interpretation where the Gramm-Leach-Bliley Act, which was ostensibly about clamping down on accounting fraud and financial fraud, was used to create criminal liability for a guy who threw fish off of his boat. So he was catching some fish. They were too small. So that's illegal because you got to throw them back. And his boat was boarded by the I think, Florida Fish and Wildlife or something. And they said, don't throw that fish off the boat. They're too small. Go into port so we can take that as evidence, and then we will charge you. And of course, the guy was like, I'm just going to throw the fish overboard. But the Gramm-Leach-Bliley law says any destruction or concealment of a record or objects is included within this record is a violation of Gramm-Leach-Bliley. And so it was very strange. Is this accounting statute supposed to apply to fish destruction? The court said, actually, the majority said, yeah, kind of. So, this is why statutory interpretation matters. And, broad statutes that seem to have a lot of possible application are a threat, even if it wasn't the intent of the person who wrote that statute or wrote that rule for that to be the targeted activity of regulation.
Right. And so the way it's written, the way it's proposed, you say could potentially cover a book. And so I want to press you on that because I think that publishing a book with methods by which one could engage in securities certainly would be speech. But publishing a book does not bring together people necessarily, does it? Or how would that work?
Well, again, bringing together orders seems to infer some sort of professional conduct where you're taking it upon yourself to represent the interests of the people involved, right? Bringing together people, bringing together buyers and sellers. I mean, if I stand on a street corner, to take an even simpler example than publishing a book, and say, anybody who wants to trade Apple stock, meet at the park at 9 p.m., I'm bringing people together by giving them a common rule set. And, you might think, all right, Peter, you're being too alarmist here. You're suggesting that, there should be some bringing together, which is more than just persuasion, even if.
No. I mean, because it's not just that there's, how do I put this? Like, I can imagine that what the SEC is going to say in response to the comment that you wrote and others is that it's not mere speech, because the people that they have in mind, and that is clearly denoted by bringing together people, you have to provide some kind of facility, right? If you look at the Exchange Act, you would think it'd be some kind of marketplace, right? In our modern world, we don't have places anymore the way that we thought about it before the internet. And so, but nonetheless, you are providing some kind of facility in which you host people, or somehow, you see what I'm saying?
Yeah, I see what you're saying, but they can say that, but they said in the rulemaking itself that persons who merely make available, whereas someone else then brings together, are subject to the definition of communications protocol system.
All right. Okay.
Uh,
Go into that. What do you mean? Go into that. Explain that.
so, I mean, we can just quote the specific
Yeah.
language in the. So this is why there was this shift from makes available, or from um, using methods to makes available, right? Because again, using methods actually starts to sound much more like the people are in my facility that I've created for them, and I'm using methods on their behalf. But make available is just, so I'm going to put this out in the world, and other people can use it to do what they want to do with it. And they're
Like
very clear.
you can imagine putting together, going to, you can imagine going to Central Park with a big whiteboard and putting, some kind of just drawing, like some kind of column where you say, if you buy, write your name here. If you're selling, write your name here, and maybe here are different prices. I
I
don't
think
know.
we should do this too. We should
Right?
get Joe Wiesenthal to do this.
To
I
do
think
this,
it's
yeah.
game.
So you do that, and then you publish, a classified ad in a New York Times. And not that I think they have classifieds anymore, but you publish a classified that says, "Meet in Central Park at this time if you want to trade Tesla stock." And you show up, and you, at that at a point of time and place, you've brought together people, and you put up the whiteboard, and you walk away. And people then, use the markers to write their names. They find each other at given the the method that you have provided with the whiteboard, and you
But
exchange.
sort of the catch here is you have to imagine a world where bearer shares are still common.
Right.
And there's nothing actually illegal about bearer shares per se. I've looked really hard to try and find if bearer shares are illegal. There's some confiscatory tax treatment if you're a corporation that issues stock as in the form of bearer shares, and some other stuff. But so far as I know, it'd be totally okay for you and me to meet in a park, Jerry, and trade, bearer bonds. It's kind of a diehard plot, but it can happen. Anyway,
but just the point is, I can also imagine folks at the SEC just scoffing at what we just laid out with the whiteboard, and saying you're being silly.
right.
You're not taking this seriously.
But now it's probably worth just quoting the actual rule.
Right.
So on page 15,506 of the Federal Register, where it was printed, in footnote 107, they say the term makes available is also intended to make clear that in the event that a party other than the organization, association, or group of persons performs a function of the exchange, the function performed by that party would still be captured for the purposes of determining the scope of the exchange under Exchange Act Rule 3B16. The Commission stated that it will attribute the activities of a trading facility to a system if that facility is offered by the system directly or indirectly, such as where a system arranges for a third party or parties to offer the trading facility. The Commission has further recognized how a system may consist of various functionalities, mechanisms, or protocols that operate collectively to bring together the orders for securities of multiple buyers and sellers using non-discretionary methods under the criteria of Rule 3B16, et cetera, et cetera. I probably don't need to quote this whole thing, but they say in multiple places here, not just in this one footnote, in other places, this footnote's the most explicit about it, that look, we're really going to classify anyone who's doing a part of this activity as a part of the exchange, and presumably be sort of jointly and severally liable for something like a Section 5 violation where you failed to register as an exchange, which has criminal and civil penalties. And so if any part includes making available a protocol, then yes, even publishing a book on Amazon is potentially subject to the rule. Certainly making true communications protocols available, whether they're the simple mail transfer protocol or the 0x or Uniswap protocol or the Bitcoin protocol, potentially. We could imagine
there's
people
BISC
trading, securities using rootstock or just using plain old colored coins. Like this Satoshi represents shares of my company.
Yeah.
And then
I don't know if you're familiar with it, but BISC is a decentralized exchange on Bitcoin.
Yeah. It's like a Lobster bisque?
BISQ.
Yeah, like
If
bisque.
you want to look it up. So, okay. And so, as you mentioned at the top, um, there are any number of things you can say about this rule. So they offered a comment period for the public to weigh in, and so we're weighing in, and there are any number of things you could say about it, and many folks have, and there's some great comments have been filed. And among other things, you could say things like, you don't have really the authority to interpret it this broadly. You could say
It's hard because the Exchange Act is
pretty broad.
badly drafted.
But you could say that. You could say you didn't do a proper economic analysis, which, by the way, uh, executive order, oh God, 12. I'm embarrassing myself for not remember the executive order, but the executive order that requires one to do economic analysis and to have it be reviewed by OIRA does not apply to independent agencies, or at least that's the way presidents have interpreted it.
Okay.
However, Securities and Exchange Commission is unique among independent agencies as having in its organic statute a requirement that it do an economic analysis and assessment of burdens. So they are under they've been singled out specifically for being the kind of regulator that has to take into consideration the economic impact of, yeah.
I'm automatically jumping to like why they've done their due diligence, like the argument as to why they've done their due diligence. It's interesting to me to think like, okay, so we're reading this as a Gorsuch or a Kavanaugh or someone who's really focused on plain statutory interpretation or rule interpretation, would read it and therefore becoming very alarmed that it's very broad. Now, another thing the SEC could say, though, is, well, we have prosecutorial discretion. We have the ability to pick which suits we bring, and we know what we mean. And so the only people who will be impacted are these 22 people we intended to, to impact. Can you get away with that? Is there a canon of statutory interpretation that is required when you do your economic analysis as an agency? Do you have to interpret your rules in a plain reading of the rule sense, or can you say, well, we're only going to go after this many, so the economic analysis is small? This is a question I don't know the answer to.
So I don't know the answer to it either, but I imagine that the court would basically look at it and say, could you reasonably, is this reasonable, right? Could you reasonably foresee any more than 22? And if it was going to be 23 or 25 or 30, the court's going to be like, look, this is fine, right? But if you've completely ignored like an entire other sectors of the economy that are going to be affected by this, the court's going to say, you need to do this again.
Yeah, and your answer couldn't possibly be, we know what we mean, and therefore we won't go after more, because of course it's a rule that's going to sit on the books beyond the current commission. So
the economic analysis just informs the rulemaking. It's not, once the rulemaking is done, the rule is the rule, right? And that's the this is not binding in any way. So we could have made all those arguments, but we chose instead to focus exclusively on the First Amendment argument, which is kind of weird for financial regulators who, I was going to say are probably not used to thinking about that, but as you discovered in your research, maybe they are more, or should be more aware than.
Well, yeah. And so, I mean, it was convenient, to be totally honest, because we were already working on a second paper about First Amendment implications of regulating open source software developers and members of permissionless blockchain networks like miners and stakers and things. And that's because the first paper we did specifically under a sort of general heading of regulation of these protocols for anti-money laundering purposes. It's my decentralized exchange and electronic cash and the Constitution paper. And we tried to keep it cabined, because otherwise I'll just write forever, to really just software development as software development. And we didn't go into things in any real depth, like, well, what about just relaying transaction messages on a Whisper, a gossip network, a peer-to-peer network? What about validating blocks? What about publishing those blocks after you've validated the transactions in them and bundled them up and done the proof of work and all that? What about all these other activities, which still are ostensibly just communicating zeros and ones over the internet? where are the boundaries as far as reasonable permission-based regulation of people doing those activities, assuming we can't just, gag everyone. Um, and so because we were already going down that road, specifically starting with a case that we referenced in that past paper, IMS Health versus Sorrel, which is about pharmaceutical data brokers and how they actually have protected speech interests or speech rights in buying and selling information about what doctors are prescribing and whether they're prescribing their pharmaceuticals or not.
So purely commercial speech.
Purely commercials, like the most,
But the rank is
to me, least sympathetic type. Like I don't carry water for big pharma, as you know. If you stop eating seed oils, you don't get sick anymore. So, so even in a purely commercial speech context, the current, close to the current court, this decision was in 2016, I think. No, 2011, actually. So the court's changed a little bit, but it's actually changed in the direction of even more stronger protection of a First Amendment rights. So even purely commercial speech gets pretty strong protection under that case, and it's sort of like there's debate about this whether it totally killed the commercial speech distinction, i.e., writing a book gets all the protection and writing an advertisement gets much less protection. But it definitely kills commercial speech as a distinct area of constitutional analysis when there is content-based or viewpoint-based discrimination, because the Vermont law that was challenged in that case specifically said academics, manufacturers of generic pharmaceuticals, they can still get this information and distribute it. It's just pharmaceutical companies and pharmaceutical detailers who are the people who are the data brokers for the advertisers. It's just these people who can't get this information or publish this information. So it's not just a ban on certain types of content, it was a ban on certain types of people expressing certain types of content. And so, it occurred to me when we were writing that paper, well, that's actually pretty good precedent then to sort of hang your hat on as far as, people who are not just writing software for open permissionless networks, but also people running those networks. Because, you might say, oh, well, mining the blockchain isn't speech. You're making money off of it. Well, the pharmaceutical companies make a whole lot of money off of trading data about prescriber information. And so it doesn't seem like making money off of your speech activity is the sort of death knell to your First Amendment protections under the current court. And it's especially not going to be the case if the law that tried to ban, say, miners or lightning nodes or anyone else on these networks was truly viewpoint discrimination, like that Vermont statute was. And so we tend to think of viewpoint discrimination in the context of like Mormons aren't allowed to talk anymore. Obviously that would be very unconstitutional because you've got free exercise of religion in there as well. But we tend to think of viewpoint discrimination as about, a political view or a religious view or a cultural view. But the court basically said, no, even if it's a very capitalist type interest, it's a viewpoint. You can't stop that. And frankly,
and quite honestly, where does the capitalist viewpoint and the political viewpoint, where does one begin and where does the other one end, right? Because given folks' feelings about big pharma and Bitcoin mining, they're just doing capitalistic activity, but people might put certain political labels on what they're doing.
Yeah, and the enthusiasm over Bitcoin is, if I had to estimate, like 2% electric money. Oh, cool, we can have e-commerce, and like 98%. Wouldn't it be great if we were able to have a free, open, permissionless way to do, peer-to-peer transactions over the internet, so we didn't have to be beholden to a corporation or beholden to a government? That's a deeply political view. So anyway, we were already writing this paper. I think the arguments are strong. But it's great that the SEC decided to publish this rulemaking because it forced me to look more narrowly, within my already ongoing research, at securities regulation. And, when decentralized exchange was first becoming a big thing, I would also sort of, always under a disclaimer, this is not legal advice, I'd say, well, watch out for the anti-money laundering rules, although they can be narrowly interpreted to cover only people who accept and transmit and therefore have some kind of actual custody over someone else's money. be really careful about the securities laws because those definitions are super broad. And I always sort of thought like, we may not have much help there, even from the First Amendment necessarily. But it turns out, to get to where you were, I think, driving with whatever question you asked a while ago. I know I've been ranting. It turns out there is a lot of case law. Well, there's one really big case in securities laws about the intersection of the First Amendment and the investor protection scheme set up by the Securities and Exchange Commission. And it's not in the context of the Exchange Act. It's in the context of the Investment Advisors Act, which is, another registration scheme for people who regularly engage in sort of a professional advice about, managing your portfolio, what stocks to invest in, what assets to diversify into, all of these sorts of things, how to manage your money. And this person isn't holding your money, they're advising you, right? And this case is Lowe versus Securities Exchange Commission. It's a 1985 case. It is as old as me. Exactly. And it's a pretty straightforward fact pattern, actually. This Lowe guy, Christopher Lowe, was a sort of disreputable investment advisor. He actually got his registration revoked for insider trading or something. I may be wrong about that, for specific malfeasance. Perfectly reasonable. And then he continues, along with some I was going to say co-conspirators, but he actually did nothing wrong, apparently, with some friends, to publish a newsletter of, hot stock tips. And there was even some...
so he's still giving financial advice.
Still giving financial advice.
Who pay
and not only that, there was some indication that the issuers of the stock were writing the articles about the stock that he was then publishing in his newsletter, like about how good the stock is.
Right.
And he never said anything bad about any of these stocks. So, you can draw your own conclusions. This is not a good guy. I'm not defending this guy.
The point is that he previously was an investment advisor. He was giving advice to clients,
right,
whom he had a direct relationship. And he was telling them, hey, this is how you should manage your money, giving them direct advice. As a result, he was licensed, let's say. It's not licensed to registration. He was registered with the SEC as an investment advisor. That's revoked. He then pivots, as we now say,
to just publishing a newsletter.
And so he's giving advice about what stocks you should buy, but he's not giving it to any particular client. He's just publishing it in a newsletter that people can subscribe to.
That's right. And the SEC went after him again because of this publishing activity. And they asked the court for an injunction against him to force him to stop publishing the newsletter.
Based on the fact that his license had been suspended. So he
yes.
can't do this anymore because he can't give out investment advice.
You're not allowed to continue. Yeah.
Right.
And this is the interesting thing about the term registration.
Yeah.
Which is the term of art in the securities laws. It really is a license.
It's a license.
It's not like you just need to phone in and be like, hey, I'm doing this stuff. And then they're like, that's the end of it. It's like, they can be like, no, you're not. Stop. It's a license.
I think the distinction that the charitable way to think about that, I think, is that registration, you merely have to register, right, and then you can be told to stop. Whereas a license, you probably have to pass a test before you are given a license or something.
That's probably right.
But the end result's the same. You have to have this thing that the government gives you, and without which you're not allowed to do your whatever business you're.
That's right. That makes sense. Yeah. Okay, so the SEC brings an injunction against, or asks a court for an injunction against him. He gets some lawyers and he challenges them and says, you can't do this. I have a right to just publish a newsletter. It's my First Amendment rights under the Constitution. And to make a long story short, it gets all the way up to the Supreme Court in 1985. And the court unanimously says the SEC can't get this injunction. The majority of the court uses a flexible statutory interpretation. They look deep into the legislative history of the Investment Advisor Act for statements from members of Congress about whether they imagined that it would apply to just publishing a newsletter. They look at the text of the Investment Advisor Act itself, which does have an exclusion for anyone who is publishing a bona fide periodical, which is like, I don't know how that got through Ledge Council in Congress, but Ledge Council back then might have been quite different. And so they say, like, well, was Congress intending to permission people who are, writing newsletters if the newsletter is like a substandard quality, like that's not bona fide? It's a little less good than Bloomberg News or the Wall Street Journal. And they said, no, that couldn't possibly be the legislative intent, because that would be unconstitutional. That would be discriminatory based on the quality of the content being published rather than something else. So clearly Congress intended to carve out any kind of permissioning of any kind of regular, dispassionate investment advice in a newsletter. And so, the majority didn't have to do a lot of deep constitutional analysis, because they used what's called the constitutional avoidance canon of statutory interpretation. They said Congress could not have possibly meant to permission certain types of publications that are just lousy, because that would be unconstitutional in the First Amendment. So Congress actually meant to carve all of this activity out. So it's actually beyond the SEC's statutory authority to go after Lowe in this case. So
they didn't say the act is unconstitutional. They said what the SEC is trying to do here would be unconstitutional. Therefore, the act couldn't have possibly
meant that.
Yeah.
Now, Justice White, who I didn't know much about, but seems like was kind of badass, wrote this great concurrence that the Chief Justice and one other justice joined. So it's a unanimous court saying that the SEC can't do this. But these three justices have a separate opinion that says, we've looked at the legislative history and we've looked at the plain text of the Investment Advisors Act, and we actually think Congress meant to discriminate between various qualities of investment advice as far as published newsletters. And yeah, they didn't want the SEC to make it illegal for the Wall Street Journal to run their business, but they definitely meant to make it illegal for someone like Christopher Lowe, a disreputable former investment advisor, to publish a newsletter. And so they didn't say, though, that this was okay for the SEC to do, to stop them from publishing. They said, actually, then, because that was Congress's intent, and that is actually the letter of the Investment Advisors Act, that aspect of the Investment Advisors Act, as applied in that context, is unconstitutional. And Justice White, therefore, had to do the full constitutional analysis. And in his concurring opinion, he's got this very pristine paragraph as far as creating a clear standard, which I think is the best standard I've ever seen with respect to differentiating between something that is perfectly constitutionally allowed to be permissioned, which is professional conduct, versus the regulation of speech as speech. Because, of course, when you regulate professional conduct, when you say, in order to practice law, which is mostly speaking, you need to get barred. Of course, you're impacting speech. But the main thing you're focusing on is the professional conduct, and the impact in speech is incidental to the regulation of professional conduct. So
there's even radio broadcasters are licensed.
Are they?
Yeah, to operate the radio station.
To operate the radio station. Yeah. My father was a broadcaster, but he was just the talent. He didn't send the radio waves out, so I guess he didn't need to get a license. So Justice White's standard that he articulates, citing a whole bunch of case law about all sorts of things, including union organizers who are giving speeches about, hey, join the union, but aren't running the union. He cites a whole bunch of cases, which we won't go into, has this good standard. And I'll just read it. One who takes the affairs of a client personally in hand and purports to exercise judgment on behalf of the client in the light of the client's individual needs and circumstances is properly viewed as engaging in the practice of a profession. Just as offer and acceptance are communications incidental to the regulable transaction called a contract, the professional speech is incidental to the conduct of the profession. If the government enacts generally applicable licensing provisions limiting the class of persons who may practice the profession, it cannot be said to have enacted a limitation on freedom of speech or the press subject to the First Amendment scrutiny. Where the personal nexus between professional and client does not exist, and a speaker does not purport to be exercising judgment on behalf of any particular individual with whose circumstances he is directly acquainted, government regulation ceases to function as a legitimate regulation of professional practice with only incidental impact on speech. It becomes regulation of speaking or publishing as such, subject to the First Amendment's command that Congress shall make no law abridging the freedom of speech or of the press. Like, that's such a good paragraph. I really like that. And so, as I said to Jerry earlier, Jerry, I was already writing this paper about like where does the line lie between conduct, which we can regulate, and speech, which we can't regulate. And I hadn't yet found Lowe, but because we were making arguments in front of the Securities Exchange Commission for this rulemaking, I was like, oh, this is a useful case.
And so then after that, it's just kind of slam dunk, as far as I'm concerned, and hopefully as far as Justice Gorsuch and Kavanaugh and the rest.
Yeah, so there's a few things in there. We kind of did this in reverse order by talking about statutory interpretation before we talked about the Lowe holding. It is a completely fair and good argument against everything I've just said to say that Justice White wrote a
concurrence.
Concurrence.
Yeah.
It's not precedential, although the majority references Justice White's concurrence in a footnote and says, we agree that professional conduct regulation can't extend to just speech. All we're saying is that Congress didn't intend it to, and therefore the deficiency with the SEC's seeking an injunction here is their lack of statutory authority, not that it's unconstitutional. But they basically adopted his test for professional conduct. And again, he cites a bunch of older cases going back to like union organizing and things like that, which have a very similar feel to it. They're just not quite as well articulated, and they're not directly in the context of securities law. So no matter what, we have a lot of good precedential ground to build this specific distinction into the standard as to whether I'm just publishing software or I'm taking the affairs of a client personally in hand and making that the standard for when we can no longer permission that activity.
And go ahead, say the but, because I'm gonna say why I think it
but also unlike the majority in Lowe, the current court is much more like Justice White.
Right.
They are not fans of legislative history or the constitutional avoidance canon. They are plain language statutory interpreters who will say, look, an ordinary person reading this is going to read this as a prohibition on publishing software. They just are. And so we have to address the rule or the statute as we find it. We can't imagine better motives because that's how a normal person is going to find the statute. And that's how the rule of law is supposed to work. And so I don't think, and Kavanaugh especially has written exhaustively about how the constitutional avoidance canon is a big mistake.
Right.
We'll just throw it out. And so that'll mean they'll have to address the actual constitutionality of the rule itself and maybe even the Exchange Act itself, because again, the Exchange Act has an even broader or more ambiguous definition of what it is to be an exchange that needs to register.
Yeah. And so what I was going to say is that the White standard just seems so eminently reasonable, right? That I can't imagine the court not taking notice of it, especially because whoever the plaintiff is going to bring it to their attention. And if you apply that test, then that's my point. This is a slam dunk applied to what we have in this instance.
Yeah, and it might be interesting for our listeners who are in this space, working on software, working on decentralized exchange tools, to look at the section where we say, and let's go beyond. Let's go beyond just publishing, say, a protocol for swapping two tokens on Ethereum and publishing it to GitHub, to an open source software repository. What other things do people do in this space? And do any of them start to actually approach that standard of professional conduct that's outlined by Justice White?
And so can I just say, that's why I was bringing up earlier, it's that we can't forget that it's also the bringing together, right? Like, because I think the SEC, what they'll say is, no, clearly you can publish a book and clearly you can publish code to GitHub, and that's speech. But this is why we have this other part of our little test, which is bring together people. Right?
I guess,
that's bringing us back.
but here's the thing, like the reason why some of these tools are better and easier to use and more intuitive than just code in a GitHub repository is not because you have a personal nexus between
Correct.
the developer and the user. What you have is graphic design, is like a button that looks like a physical button in the real world, is
a widget that you can embed into any website that allows you to interact with a smart contract on Ethereum.
A paragraph written in plain English rather than C++ that explains, things you could do with this tool that I've made and ways to, go through the process of using it, so you're not scared. And so all of this, and even operating a website that actually hosts this stuff, not just giving it to GitHub to host, although you're probably paying for that on GitHub, maybe not, I don't know. Actually, I guess
you could do it for free or not.
Yeah. Even though if you were directly hosting the website and making advertising revenue off of the website, like Christopher Lowe made money off of his newsletter. He was publishing it directly. It was a recurring thing. So it's hard to see at what point we actually hit the Justice White standard. And that's going to worry, I think, a lot of people, because it may mean that there's a strong constitutional bar to doing the kind of investor protection regulation that a lot of people might want to do in a world where everything is trading using software instead of the New York Stock Exchange. But this is
we don't want to minimize that, because I think there are some very legitimate concerns about investor protection, especially from folks who would love to see more stricter investor protection than we currently have. And by completely disintermediating the parties that would normally be subject to the regulation, there's just no longer a opportunity for that kind of regulation.
Yep.
And we're saying, well, take it up with the First Amendment. That's not, take
it up. So if you want to do this on a permissioned basis, you got to take it up with the First Amendment. But maybe there's other bases. There's even I left some breadcrumbs in here. Like there are anti-touting provisions of the securities laws.
So I was going to say,
there's fraud. There's if this person is doing things to say like, hey, come trade some synthetic Tesla stock using my tool, I'll help you or whatever, then maybe you can go after him for something else. But I'm not sure merely by publishing that tool. Well, I don't think you can go after him for being an exchange.
Yeah, and I think, and that's kind of what I, maybe I was being too glib, but when I would say take it up with the First Amendment, what I'm referring to there specifically is the idea that there always has to be an intermediary that is easily regulable.
Yeah,
can't help you there, but as you say, doesn't mean all hope is lost. It doesn't mean that there are not all manner of things that we can do to protect investors, and in particular, there are any number of things that we can do that we've always been able to do before the securities laws to combat fraud, right? And so, you can see, different developers of decentralized exchange protocols make available different products, and on some you can see all kinds of promises being made, and in others you don't. And there's that's a distinction there.
Yeah.
You said that this could go all the way to the act. So not just that so that, and by the way, just again to remind people of the posture, this rule has not changed anything yet. This is a proposal to change it, right? The SEC will at some point finalize this rule, and either they will take everything we've said to heart and amend it so that it's not so broad, and they will narrow it in such a way that it does not impinge on speech, or they'll say, we hear you, but we think we're okay, and just publish it and finalize it the way it is, and that becomes the new rule. And at that point, somebody, maybe us, maybe probably somebody else, will go and file in federal court and say, look, you can't do this. And at that point, what a plaintiff will say is, hey, Supreme Court or federal court, this new rule this rule change, this amendment to the previous interpretation of exchange, creates a prior restraint on speech, which is unconstitutional. And so, what a court could do, if they agree, is to say, okay, you're right, and that's stricken. And so we kind of revert to the old standard, or the SEC has to do new rulemaking or whatever.
Yeah.
But that is not the rule. But you're saying that they could go further and say, not only is the rule unconstitutional, but the Exchange Act is unconstitutional.
Well, so it's a whole thing, right? So you can imagine that, a good plaintiff. So let's actually first deal with the procedural issue, because there's an interesting thing we mentioned here, is that under some more recent First Amendment precedent at the court, plaintiffs can bring pre-enforcement challenges. So we don't even need to wait for we wait for the rule to become final. As Jerry said, the rule is just proposed right now. And I'm saying we, not necessarily Coin Center, because there probably are better challenges.
The community.
The community. We wait till the rule's final, and then we don't have to wait for the SEC to enforce against somebody writing DEX software. We don't have to wait. In most cases, you have to wait because you need standing, you need to prove injury, you need to say, like, look, you can bring facial challenges. This is called a facial challenge. It's not an as-applied challenge, but you can bring a facial challenge against a new law. But in most cases, you have to say that there's just nothing legitimate about this law. Like it plainly has no legitimate sweep.
Facial means that on its face, it's
on its face, it's unconstitutional. But in the First Amendment context, the bar is actually a lot lower to bring a facial challenge. You don't say that it has no legitimate sweep, or there's no circumstances where the law as applied would be valid. You simply have to say that a substantial number of the potential applications of the law or the standard are unconstitutional, such that when people see this law, they feel the need to self-censor for fear of being one of those several, persons performing an activity that is no longer allowed. And then they self-censor, and that's a chilling effect on our constitutional protected speech rights. And therefore, we want to allow facial challenges to prevent the chilling effect. And the chilling effect is very real. I mean, you can definitely see why, if you are a developer of perhaps highly innovative, very cool technology that may be used to trade securities, but may be used for other things too, and you happen to be located in the US, and you were thinking like, well, geez, I want to keep publishing these software libraries. A lot of people use them and like them, and they seem safe and effective. Maybe I'll move to Belgium. I don't know. I don't know if I want to be involved.
And you can imagine, intermediaries like, let's say, GitHub or Google saying, like, this is like a minuscule portion of our business.
Yeah.
We just want nothing to do with this, right?
We're just going to stop republishing this speech for them. Yeah.
Right.
And so because of the danger of this chilling effect, the standard for when you can bring pre-enforcement facial challenges to the law is much lower in this context. So we don't have to wait for enforcement. We don't have to prove that the whole thing is illegitimate. All we have to prove to bring a case invalidating this rule, which would take a long time in the courts, but we could start right away. All we'd have to say is that it burdens a substantial amount of speech and would chill constitutionally protected expression, which I think is a pretty easy case to make. And so then the question is, what happens when that challenge goes forward? Does it end up invalidating just this rule, and then they have to go back and they have to either use the old rule definition or create a new rule, or does it invalidate the Exchange Act itself? I think any good plaintiff is going to make the argument that there isn't statutory authority here, right? Because I was saying earlier, that argument's kind of weak. And they can make other interesting arguments along those lines too, that like maybe there's statutory authority, but it's impermissible delegation of legislative authority from Congress to the agency. There's lots of arguments you can make there. We don't make that one in this comment. And the SEC, the government's going to have to come back and say, no, the statute is clear. It gives us the authority to do all of this. And that's why we're doing it. We're doing what Congress told us to do. We're not stretching it. We're not doing other stuff. At which point, then, that's probably right, because the Exchange Act is extremely broad. It doesn't have a carve out for bona fide publications like the Investment Advisors Act. It doesn't have any carve out at all. It has their definition has no mention of this professional nexus. It's very broad. And so a court that takes the First Amendment challenge very seriously, which I think the Supreme Court would, a lot of circuits in this country would be faced with this issue. Well, crap. How do we sever the constitutionally deficient parts of the Exchange Act from the rest of the act? And we're not talking about some like doodad attached to the act. We're talking about the core definition of exchange. So, at this point, I'm worried that I'm too confident in the vindication of First Amendment rights, because would we really eviscerate a very large part of our investment protection regime in order
I
to
don't think
defend
so.
those rights? The Constitution says we would, but is Congress going to go fix that quickly? God, can you imagine if we had to rewrite the Exchange Act in 2023 or 2024, rather? That would be a nightmare considering the way Congress works these days.
Yeah, which is why I don't think the court would do that.
They'll find some.
They'll find a way.
The legal term here is severability. Can you sever the deficient parts from the existing structure? Maybe, but they're not allowed to rewrite the statute. That's the thing. Like, you'd think they could just take Justice White's professional conduct statute and put that in, or standard, and put that into the exchange definition. That no judge will do that, because judges know they can't just write legislation.
Well, this court won't do that.
Yeah, that's true. Fair. A fish can be evidence for accounting fraud. Yes.
So what else do we need to talk about with this? What were we skipping over?
I think we got most. The last bit is just where we say, like, look, we know we just made a long First Amendment argument. We don't want this to happen. The SEC has been sensitive to First Amendment issues in the past, and we cite a really interesting speech that I hadn't found before by Roberta.
I was going to say, I want to bring that up.
Who was the first woman commissioner in the 70s, and she said, we in this speech, she says, we changed a rule because we realized that it was potentially, impacting too much protected speech, and that's important. And so there's a precedent here, if you will, of an agency sort of changing direction mid rulemaking out of recognition of the First Amendment issues. And of course, one of our current commissioners, Hester Peirce, we need to go back now and see if she actually mentioned First Amendment in her speech.
I'm like I looked. I'm like 99%.
Okay, it's cool. Either way, I think they're, I don't know what's going on at the SEC these days, but I do hope they read our comment and they don't take it as combative. And I know they'll read it, but
no.
They recognize that, well, maybe there is a path forward to do what we wanted to do with the Bloomberg terminal and not, jeopardize the mere publication of software or permission that.
Yeah, I mean, so if I had to bet, and I really hope that I'm, please SEC, prove me wrong. But if I had to bet on how this will proceed now, I think the SEC will certainly read our comment and all the other comments that were filed seriously, and we'll take them very seriously. And they will even address our comment in the ultimate, in the final publication of the rule. But if I had to bet, I think what they will say is that they disagree with the analysis.
Yeah.
And I think they'll say that it's interesting. I don't know what they're going to say actually about the. So it's very interesting, right? So given the economic analysis that they did, where they said that only 22 parties would suffer a burden. What they're implicitly saying there is that DeFi, decentralized exchange, will not be affected by this. So one thing they could do is to say, much like the Treasury Department has said, that under the tax provisions of the infrastructure bill won't affect miners and node operators.
Right.
Of course, if you read the text of the statute, it could on a dime be applied to them. But they've said, oh, we have no intention of using this language that way. So they could just kind of reiterate who they want to. Now they may not do that though, because they also don't want to tie their hands, because once you do use it in the future, then in addition to all the claims that you mentioned would be in a lawsuit, you could add APA
Yeah.
to the list, Administrative Procedure Act violation to the list. So that's going to be interesting to see how they square that. But they could also, but if they do want to concede that they do intend to potentially cover DEX, I think they would say things like, and we've heard this when we've talked to our friends at Treasury, for example, where they're like, well, this is a place. This is you're providing a service, and you do have a privity with, they're coming into your home, and you're providing, et cetera, et cetera. And so they're going to have that conception, I think. But that's just my rank speculation.
There's another aspect of this that it's funny. One of our favorite Twitter accounts was asking about like whether Congress considered indexing the BSA thresholds for inflation. And I said, look, I actually didn't look into the legislative history because the judges today especially the ones that we think would probably be allied up with us on things like speech issues, tend not to care about legislative history.
Right.
It's the word of the statute that matters. I would be really interested, though, in both looking at that, like what were the discussions about when a report is triggered, the size of the transaction, the amount of private data included, things like that. To the extent there were discussions about that in the 70s with respect to anti-money laundering policy. Also be very interested in learning more about the legislative intent behind the Exchange Act, because it's a tumultuous period of American history right after the Great Depression, or in the midst of the Great Depression, right after the, like bonanza of everyone getting involved in the stock market and it not turning out so well for a lot of people. And probably, like, it is my guess, and this is interesting then, that the early stock exchanges were kind of like, hey, if you want to trade Apple stock, meet me in the park at 8 p.m. Like Lloyd's of London was a coffee house.
Yeah.
And so, like, and this goes to the question of like whether the act itself might be unconstitutional, because I think the act might have been really deliberately written to just say, like, if you're a group of people that regularly trade stocks with each other and have come up with rules amongst yourselves for how to do that, that's an exchange.
But so you're right about but I think I think by the time the Exchange Act came around, and we're exhibiting our ignorance here of history, but I think by the time the Exchange Act came around,
it had been professionalized.
Totally professionalized.
Absolutely. But I think even if it had been professionalized, there were probably more and less professional examples, right? And that the ones that they tried to get rid of were the less professionalized ones.
That's interesting, yeah. Well, the good news is that unlike probably the BSA, there is no doubt a lot of history that you can easily dig up on this, right? I mean, I'm sure there's been a lot of scholarship done on that. Anyhow, well, so that's it. So we filed our thing, and now we wait. And we'll see. But it's really interesting seeing a lot of the challenges that our European friends are having these days. What a blessing it is for us here in the U.S. to have the First Amendment right there.
Yeah, it's hard. Like, I can't imagine making arguments against MiCA, which is a proposal for regulating, from an investment protection standpoint, a lot of potential software development in Europe. I can't imagine you make the best arguments you can, given the statutory and constitutional authorities you have, but it's hard to make an argument that defends people's right to publish software on purely economic grounds. And this is something that I think a lot of folks that we talk to struggle with, because they're like, show me the actual, like, very real good that this technology is doing in the world. And we have good anecdotes. God knows we have lots of good anecdotes, and the plural of anecdotes is data. But, if you do a cost benefit analysis, you're just making so many assumptions.
Yeah.
And the biggest assumption is, like, what will this technology be doing in 10 years? And nobody knows the answer to that. And that's why we have a First Amendment.
Correct.
It's like the marketplace for ideas is going to go, and that's the best way to have progress in science and arts and culture and the humanities. And if we presuppose that everything that's going to be written in the next 5 years is freaking lousy, and we ban it because of that, then, like, we're not going to know that progress. And so, like it's hard without a First Amendment. It's hard to have a consequentialist approach,
Right.
moral approach to speech rights. You really have to be sort of deontological. You have to be like, no, this is just something about human dignity that we don't mess with.
Yeah, I like to lean more on the liberal part of liberal democracy.
Classically liberal?
Well, yes, that's what I mean. Liberal democracy. Anyhow, this was a delight, Peter. I hope people enjoyed nerding out.
Yeah. I hope the SEC enjoys nerding out.
All right. See you next time.
Bye, Jerry.